Reasonable efforts to prevent need from removing a child from its home need not be made if the parent has subjected the child to aggravated circumstances.
True.
Is true. 3. Placement may be with siblings unless such placement is contrary to the child's best interest.
That is false, because placement shall be with the siblings.
If a child is placed in foster care, the court shall schedule a permanency hearing pursuant to FCA 1A for a date no more than
8 months?
Yes. 8 months.
Woo!
After the placement of the child in foster care.
All right.
Okay.
So 8 months after
foster care placement. 5. Reasonable efforts to prevent the need from removing the child from its home need not be made if the parent was convicted of murder in the first degree or manslaughter in the first degree and the victim was
another child of the parent.
Yes. Isn't it also attempted?
Oh yeah, attempted.
Oh, voluntarily attempting or soliciting or facilitating or guilty of actual murder in the first degree or manslaughter in the first degree.
Okay.
So it's all of that. Okay. If the court finds that reasonable efforts to prevent the need from removing a child are not required, a permanency hearing shall be held within blank days of the finding.
30 days.
Oh, dirty 30.
Oh yeah, dirty 30.
Dirty 30. 30. Okay.
Closed out Panera.
They were like, last call.
They were like, we're gonna put this bad music louder and louder until you leave.
Oh my god. Okay. Okay, which of the following statements are true? I'm gonna change it. Reasonable efforts to prevent the need for removing the child from its home need not be made if...
I'm gonna open my book to cheat in case I need to cheat. But I think I know some of them. So, the child was subjected to aggravating circumstances. Is that one?
Yes.
There's been a termination of parental rights for another kid of the parent. The ones about the convictions.
Yes.
So there was like the murder in the first degree, murder in the second degree, manslaughter in the first, and the victim was another child of the parent. And is there more?
No, that's it. You're right. That's it.
And then the aggravated assault on less than 11-year-old, that too, and an attempt, and the victim was the child or another child of the parent. And okay, cool.
That's it.
Okay, no more cheating then.
Okay. At a permanency hearing, court shall determine if the child should be 1. Returned to the parent, 2. Referred for the legal guardianship, 3. Placed for adoption or placed in another planned permanent living arrangement. Which one of those are true? Is it all of them or certain ones?
It's all of them.
Yes. So again, at a permanency hearing, court shall determine if the child should be 1. Returned to the parent, 2. Referred for legal guardianship, or 3. Placed for adoption or placed in another planned permanent living arrangement. Okay. 4. Choose the best answer. An order of placement shall include, if the child is at least 14 years of age, an order for services to
transition the child into independent living? Is this?
Yes, close. Assist the child to make the transition from foster care to independent living.
Oh.
Transition. Independent living.
Oh, shit. Again.
Okay. Okay, the last one. The following are deemed orders of disposition and appealable. 1. Order denying a petition filed by a social services official, and 2. Order granting petition filed by parents for return of a child.
They're both true.
Yes.
So that would be the order denying the petition, the social services official could appeal, or the other one, the parent would appeal. I think.
There's a lot of questions on the 385. Whatever.
Okay.
Okay, the last one. The following are deemed orders of disposition and appealable. 1. Order denying a petition filed by a social services official, and 2. order granting petition filed by parents for return of a child.
Both true.
Yes.
So that would be the order denying the petition, the social services official could appeal, or the other one, the parent would appeal. I think.
There's a lot of questions on the 385, whatever. 383.
All right,
You
let's
wanna
see.
do them?
Yeah, let's see how many we can do.
Okay. Now this is 383C. 1. A child in foster care shall remain a child in the care of an authorized agency pursuant to Social Service Law 384A or Articles blank, blank, or blank of the Family Court Act.
3, 7, and 10.
Yes.
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 I got that wrong inside. Now I remember it.
I'm just thinking anytime that they can be put into foster care.
But in because in Article 6 they're already in foster
Yes,
care.
they're being terminated.
Yeah.
So article like PINs, a JD, and
Article
neglect.
10, yeah.
They're
okay.
all like they can be put into foster care. Okay, 2. Surrender is a written instrument committing the guardianship of the person and the custody of a child under the age of blank to an authorized agency.
18.
Was that 18? Oh yeah, 18. That's right. Okay, 18. Okay, 3. An authorized agency shall not accept a surrender instrument conditioned upon adoption by a person unless the person is a certified or approved foster parent. True or false?
That is...
I'm going with true.
I'm going to go with true also because I think I guessed false before and I was wrong.
True. Yay.
Okay.
4. A surrender agreement may provide for communication or contact between the child and the child's parents and siblings. Siblings blank or over must consent in writing for agreement to be enforceable.
I'm going to go with 14.
Yes, it's 14.
It's 10 when they have to get to be served and it's 14 consent. Okay.
Yeah, 5. A judicial surrender becomes final and irrevocable immediately upon its execution and acknowledgement. True or false?
That is true.
Oh yeah, I was thinking.
And the
true.
judge has to, the judge or the surrogate
True,
has
it
to
is.
tell them that final.
Okay, 6. Any witness, if so commissioned, may or may not serve as a notary in an extrajudicial surrender. So any witness, if so commissioned, may? I don't know. I'm guessing.
I'm
may.
guessing too. I'm going to say may because if they're so commissioned.
May. Any witness, if so commissioned, may serve as a notary in an extrajudicial surrender. It's may.
Okay. Oh, it says at least one of the witnesses who's a social worker or an attorney, and that is the person that can't be an employee, volunteer, consultant, or agent for the authorized agency. So it's the witness has to be...
The lady's dancing while she's cleaning, sorry.
Oh, that's great.
Okay.
But the notary can be an employee.
The notary can be, okay. Okay, 7. Within blank days after execution of surrender, the authorized agency shall file an application for approval of the extrajudicial surrender in the court.
It's within 15 days.
Oh, it's 15 days? I was
They
gonna
have to
guess
file
20.
it.
Oh my god, it's 15!
Yeah.
Okay.
So that is within 15 days they have to file the application for approval of an extrajudicial surrender. An extrajudicial just means it wasn't done before a judge or a surrogate. It was done before like the notary and the social worker and that crap.
Okay. So it's outside of judicial people who are in the... Okay.
And they just call it an extrajudicial.
Okay, 8. A person who received notice of a hearing to approve an extrajudicial surrender may not challenge the validity of an approved surrender in any other proceeding. Is that false?
I'm going to say that they received notice. I'm going to say that's true.
It's fucking true.
Okay, say it again.
Okay. A person who received notice of a hearing to approve an extrajudicial surrender may not challenge the validity of an approved surrender in any other proceeding.
Okay.
9. A judicial surrender instrument shall state that surrender becomes final and irrevocable immediately upon execution. I'm saying true because didn't we say that before?
Yes, and the judge or surrogate, when it's a regular surrender, a judicial surrender, shall inform the parent that the surrender becomes final and irrevocable immediately upon its execution and acknowledgement. And yeah, so that's true.
Yeah, that's true. Okay. 10. Revocation of an extrajudicial surrender is effective if it is in writing and postmarked or received by the court named in the surrender within blank days of the signing of the surrender.
I don't know. Should I guess?
Just guess.
60?
Oh, I was thinking 30, so let's see what it is. 45!
Oh!
It's between 30 and 60. Okay, so revocation of an extrajudicial surrender is effective if it's in writing and postmarked or received by the court named in the surrender within 45 days of the signing of the surrender. Okay.
Now, is that an extrajudicial surrender? It's talking about a regular.
Extrajudicial.
Time rules so far that we have 15 and 45.
Yes.
Okay.
15 days to file an application.
A application for approval of the surrender. That's the 15 days.
Within 45 days of the signing of the surrender. Revocation of an extrajudicial surrender is effective if it is in writing and postmarked, or received by the court named in the surrender and received within 45 days of the signing. 11. Surrender shall be recorded in the office of the blank in the county where the surrender was executed or where the principal office of such agency is located, in a book kept under seal and subject to inspection, only as provided by Social Service Law 372 sub 3 and 4. Like, somebody really fucking do that?
All right, so I'm going to go with it's either the family court or surrogate's court.
You're going to be pissed. The county clerk.
What about the county clerk?
The county clerk apparently has shit to do with the foster care and civil. I don't even know. Okay, let me just reread it. Surrender shall be recorded in the office of the county clerk. Right? Yeah, county clerk in the county where the surrender was executed or where the principal office of such agency is located, in a book kept under seal. Like, to me, that means, like, the book is, like, kept, like, under somebody's desk. Under seal and subject to inspection, only as provided by Social Services Law 372 sub 3 and 4. Does anybody work in the fucking county clerk's office? Because I don't even know anybody who works there.
I know one person that used to work there, and you know what it says here about this?
What?
It says that there's a form that they fill out for the public health law, and upon the adoptee reaching the age of 18, they could find out, like, their health information.
What?
And then it says that any fee authorized to be charged by the state adoption registry for filing the documentation shall be waived for this. And it is about the county clerk.
It says the county clerk?
It says, a surrender shall be recorded in the office of the county clerk where the surrender is executed. Surrender is executed. Okay, so it's either where the surrender is executed or where the agency has its principal office. Now that sounds like civil. He has its principal office.
Let's go on to the next question.
Okay.
Surrender instrument, and surrender paper shall refer exclusively to adoption of children in foster care. True or false?
False.
I'm thinking true. 12.
Oh, wait a minute. Yeah, because they're surrendered to the authorized agency.
Yeah, it's true. Surrender instrument, and surrender paper shall refer exclusively to adoption of children in foster care. True or false?
It's true. Okay.
It's true. Oh, that's you guys. We
Yeah.
don't need to do that. Okay, 13. If court disapproves the surrender, or if revocation of a non-judicial surrender is mailed and postmarked or delivered to the court within blank days of execution of surrender, surrender shall be deemed a nullity, and the child shall be returned to the authorized agency.
45, because we
Yes,
just did it.
45. Didn't we just do that?
Yes, that was
Okay.
the 15 and 45 for the
Yeah,
extrajudicial.
45, yeah. Okay. 15. If the child was in foster care as per FCA 10 or 10A or Social Service Law 358A, then extrajudicial surrender must be filed in the court that exercised jurisdiction and assigned to the judge that last presided over the case.
Whenever practicable, true.
Oh wait, hold on, that's on the next page. True, yeah, it just says true. But it could be whenever practicable.
I think it
but
said
it is.
whenever practicable.
It does say whenever practical.
Okay.
Practicable. Whatever. Somewhere. It said I don't know about this article because I didn't even read it. 16. Adoption proceeding in the case of an extrajudicial surrender shall be initiated more than blank days after the surrender is executed.
It shall be initiated.
10 days? 20 days?
Is it 15?
16. Fucking 45. There's only 15 and 45 day rule. That's it. Adoption proceeding in the case of an extrajudicial surrender shall be initiated. Oh, wait, hold on. Adoption proceeding in the case of an extrajudicial surrender shall be initiated more than blank days after surrender is executed.
45 days for the person to pull it back. So that's why they're saying you have to wait 45 days to start the adoption proceeding.
Yes. Yeah.
So that actually makes sense.
Something makes sense in
Yay!
this thing. 17. Persons having custody of children for more than blank months have the right to intervene in a proceeding commenced to set aside a surrender. Intervention may be made anonymously or in the true name of such person. Intervention may be made anonymously or in the true name of such person. A person having custody of a child for more than... I'm going to go with 12 months.
I think you're right.
Only because if termination of parental rights is...
Yeah.
12 is what I thought it was a year, but I think it's 12 months or 15
Yeah,
out
I
of
think
22.
you're probably right.
It's 12.
Woo!
Oh my god, educated guess.
Okay.
A person having custody of a child for more than 12 months have a right to intervene in any proceeding commenced to set aside a surrender. Okay, intervention may be made anonymously. No. That was the end of the sentence.
Okay.
So now we have a few questions. Only
Okay.
11, and then we'll be done.
Yay.
I gotta drive. I think it's gonna take me like an hour to get home. Oh my god, it's 12 o'clock. Okay, 1. Which of the following 4 statements are correct? A surrender is signed. I have to look at the answer for this because I don't even know. Okay, I know it now.
A surrender is signed?
Yeah, a surrender is signed. Okay. Which of the following are correct? A surrender is signed, A, by both parents if living, or one parent if the other is deceased. B, by one parent if the other parent abandoned the child for 6 months, as per Social Service Law 384B. And C, by the mother if the child was born out of wedlock, and the father if his consent would be required for adoption. It's all 3 of those. I just read all of them.
Okay, so it's all of those.
Yeah.
Okay. Do you want to read them one more time?
Okay,
So we
yeah.
get clear.
Okay. A surrender is signed, A, by both parents if living, or one parent if the other is deceased. B, by one parent if the other parent abandoned the child for 6 months, as per Social Service Law 384B. So that goes against what I said before. And C, by the mother if the child was born out of wedlock, and the father if his consent would be required for adoption.
Okay.
2. A surrender of a child to an authorized agency for adoption may be executed and acknowledged before
A judge of the family court or a surrogate.
Yes, only before a judge of the family court or a surrogate in the state. Perfect. Okay. 3. Which of the following statements we're going to go with true? If surrender is not executed and acknowledged before the judge, so this means it's an extrajudicial surrender.
Right, yeah.
Okay. I'm like understanding a little bit. At least one witness must be an employee of an authorized agency trained to receive surrenders. This is what you just said. 2. at least one witness shall be either a licensed master social worker, an attorney who is not an employee, volunteer, consultant, or agent or for agency to which the child is being surrendered. And 3, must be done before a notary public or other officer authorized to take proof of deeds.
All right, that is, I think, what I said before.
Yes.
Okay.
Which of the following statements are correct? After execution of surrender, the authorized agency shall file an application for approval of the extrajudicial surrender in the court. 1, in which the adoption proceeding is expected to be filed.
Yes. Or where the agency has its principal office.
Yes. Is there anything else? Let me see. Because they have another. And 3, if the child, I don't know why I just said 3. If the child was in foster care as per FCA 10 or 10A
Oh, yeah,
or Social
this
Service
thing.
Law 358A, application must be filed in the court that exercises jurisdiction and assigned to the judge that last presided over the case.
Whenever practicable.
Yes. The following is correct. The application for approval shall have an affidavit from all witnesses of the surrender stating, do you know any of them?
Was the surrendering parent offered counseling? And if they were offered counseling, did they accept it and the nature of the counseling? That the person is aware that it's going to be effective from when it's executed. Jen, is any of this true?
Wait, hold on. No. Okay. Application for approval shall have an affidavit from all witnesses of the surrender stating the date, time, and place where the surrender was executed and acknowledged. 2, that the parent was provided with a copy of surrender. And 3, that the parent executed and acknowledged the surrender.
So I don't know what the hell I was talking
I don't
about.
know what you were talking about either. I'm like, wait a minute. None of this. I'm like, which of the following statements are correct? In an extrajudicial surrender, the authorized agency must affix an affidavit by an employee responsible for supportive counseling that, this is what you're talking about.
Oh, this.
Responsible for supportive counseling.
So, okay. So this is what I was confused by. Okay.
The other one was an affidavit from all witnesses of the surrender.
This one is.
So, yeah, the other one was, my boob is itchy. I'm sorry. I don't know why. Sorry.
Like 100% female now.
Okay. Okay, so this is an affidavit from all, okay, the first one I said was affidavit from all witnesses of the surrender. So if they were there and saw the surrender, that's what they would be talking about.
That's the date, time, place thing?
Yes.
Okay.
This next one is an affidavit by an employee responsible for supportive counseling. Okay, so wait, which are correct? So 6. All right. Okay, so this is supportive counseling it has to state that supportive counseling was offered and that if accepted, the nature of the supportive counseling and when provided.
All right, so that's different than just everybody that were there.
Yes, the other one is everybody's there, and this one is they gave supportive counseling, and they're going to see if it's that, and it has to say that it was offered, and that if they did need was and what they're going to be doing.
Okay.
Yeah. Okay. Good. Okay. So next, if there's a substantial failure of a material condition in a oh my God, it just got really dark. Oh, my truck's over there. Okay. If there's a substantial failure of a material condition in surrender instrument, after court approval and before the final adoption of the child, the agency shall file a petition within blank days of failure for conduct to review the failure, and in the absence may be filed by a parent or law guardian within blank days after notification of the failure, but prior to the adoption of the child.
Okay.
Do you
So
want the
I
choices or
accidentally
no?
cheated on this one.
Oh.
So I know that one of them's a 30 and one of them's a 60. But I don't know which
that's
one
what
is
I was
which.
thinking.
One of them is a 30 and one of them is a 60.
Okay, that's what I was thinking. So let's see. 7 is D. Oh yeah, okay. So, okay. If there is a substantial failure of a material condition in a surrender instrument after court approval and before the final disposition, a final adoption of the child, the agency shall file a petition within 30 days of failure for the court to review the failure, and in the absence may be filed by a parent or law guardian within 60 days after notification of the failure, but prior to the adoption of the child.
I'm just taking some Tylenol. Okay, so an agency is supposed to do it within 30, and if the agency doesn't do it within 30, basically, then those other people could do it within 60 days of being notified of it.
Yeah. An extrajudicial surrender instrument must state that the authorized agency shall notify the parents within blank days of any substantial failure of a material condition of the surrender prior to the finalization of the adoption of the child. Gas. No. Wait.
20 days?
It's 20 days. No. Wait.
20 days?
It's 20 days. 20 days. If you're not sure, just guess 20 days. 20 days. If you're not sure, just guess 20 days. 9. An extrajudicial surrender instrument shall state that the agency will file a petition within blank days of failure for a court to review the failure. Didn't we just fucking
This
do
better be
this?
30 days.
This isn't
Is
this,
it
did
30
we just do
days?
this?
I'm going to be pissed if it's not 30 days.
Yeah, it's a 30 and 60. It's the same fucking question that we just did.
Well, at least we're reviewing it.
I'm like, I just read that. Oh, shit. Okay. So, next one.
Okay.
Okay. 10. Upon execution of surrender instrument, parent executing the surrender shall provide the following information, if known, about the person to whom parent was married at the time of the conception of the child and any other person entitled to notice.
The following information. Their like name, last known address, and social security number.
Yes!
I just totally.
Yes!
Oh my god!
You got it all right in the
the order?
exact order that it
We
said
must
it.
have done it in there, and like my because I didn't even think. I just like spat it out.
That is so funny. Okay, last one. Where there is an agreement for adoption of a child and after approval of a judicial surrender, if it is determined that pre-adoptive parents will not adopt the child, or if there is a substantial failure prior to the finalization of the adoption of a child, the agency shall notify the court and law guardian within blank days and shall file within blank days a petition for the court to review such fucking failure. In the absence of such filing, parents or law guardian of a child may file.
There's 20 days for them to notify the parent.
Yes.
30 days for them to get their ass to court and file. And then
Yes.
if they don't, 60 days from within when the parent was noticed.
Where there is an agreement for adoption of a child and after approval of a judicial surrender, if it is determined that pre-adoptive parents will not adopt the child, or if there is a substantial failure prior to the finalization of the adoption of a child, the agency shall notify the court and law guardian within blank days and shall file within blank days a petition for the court to review such fucking failure.
So it could be up to 80 days after the actual failure of the condition.
Yes.
Because it would be 20 days for the parent to get the notice, and then another 60 they have to go and...
The question.
Yay!
Yay. Oh my god, we did a lot.
We really did. I can't wait till this is like all up.
We did a lot. Okay, I'm so happy about that actually.
Me too.
Okay.
How am I going to remember the fucking county clerk in that? It's so weird.
Well, it's weird, so maybe that's why you'll remember it.
I hope so.
It's like out of nowhere, a county
And their
clerk
book.
with
Their book and page.
it's sealed. All I think is like it's like hidden in somebody's desk.
Like the smelliest employee. They're like, all right, let's put it there. So nobody will want to go over there and look at it.
Oh my god, I can't. And can I just